Just didn't want to mislead you folks.
All right, and we are to our third case, Cooper versus Gonzalez. And counsel, whenever you're ready.
May it please the court, I'm Warren Kwabnik on behalf of the defendants, appellants, Kip Cooper and Classic Plumbing of Brevard. I'd like to reserve 5 minutes, please. The jury in this auto negligence case awarded nearly $900,000 for claimed injuries to the plaintiff's neck, back, and shoulder. We're asking that the court reverse for a new trial. We've raised 3 issues on appeal. With my time, it is my plan to talk about my first 2 issues and rely on my brief for the third involving the jury instruction. Although, of course, anything the court would like to discuss, I'm happy to do so.
Well, thank you.
That's why I'm here, Judge. On our first point, we believe the trial court abused its discretion in excluding certain testimony from the defense orthopedic surgeon, Dr. McBride, to the effect that the plaintiff's low back herniation was not caused by the subject accident.
It's your time and you can use it however you want to. From what I could see, Dr. McBride waited pretty doggone late to look at the records and came up with opinions pretty doggone late. And after the first trial, correct me if I'm wrong, but after the first trial, pretty quickly a blanket order was issued on rollover cases that these cases are done, they're ready to go, and they'll be set for trial in November or whatever it was. Is that basically what happened?
That's basically it, yes.
Okay.
So what we're dealing with here, and when the case comes up for retrial, Dr. McBride's new opinions are excluded. And we know, and this is where I think the judge, of course, committed an abuse of discretion. We know from the Binger case and all the cases that follow it, that the trial court's discretion to exclude an opinion that's rendered untimely under the court's order has to be guided first and foremost by a determination of surprise or prejudice, also considering opportunity to cure the prejudice, as well as other factors such as good faith or bad faith. The case law tells us that it's error to exclude an opinion even after the court-ordered deadline when there is no prejudice to the opponent, and I think that's what we have here. Dr. McBride solidified...
But something, that's got to be an end at some point.
Well, of course.
I mean, I'm not following that argument.
Well, there would have been no prejudice to the plaintiff by allowing Dr. McBride at the retrial to testify that there was no causation between the accident and the herniation. The plaintiff was aware of that opinion by virtue of it having been disclosed during the first trial 46 days before the trial.
But I thought the new opinion was somehow different because it's a new opinion.
No.
The opinion, again, correct me if I'm wrong, but McBride kind of went from, I can't really link it, like a second opinion was, I'm thinking it'd be hard to link it, and then the third opinion that defense really wanted in was, it ain't related, it's not causally related, and the care wasn't needed, right?
Correct, and the definitive no causation opinion was disclosed in the midst of the first trial 46 days before the second.
The defendant agreed was definitely untimely, and you alerted plaintiff's counsel to this untimely opinion, right?
Correct, and that's why everyone agreed it wouldn't be presented during the first trial.
And how many days after that trial ended with a mistrial was this blanket order that came out saying, no more discovery, no more anything?
I can tell the court...
A few, right? Just a few?
Oh, yes, it was very quick.
Right, and then it was set again for trial in November. This was October, sometime in October.
About a little over 6 weeks between that.
Okay. But if you wanted to bring up this new opinion that was admittedly untimely at the first trial, why wasn't it raised and said, Judge, we want to get this new opinion in so that he could be put up for deposition or whatever else? I mean, as my colleague related, I was a trial lawyer. If you had a problem and you had a mistrial somehow and you had evidence that was excluded in your first trial and you wanted to get it in the new trial, you'd go to the judge and go, hey, Judge, I know it wasn't fair then, let's take care of it now. Right. And that didn't happen.
No, that would have been the cleaner way to do it, of course. But in terms of whether the plaintiff was aware that we were going to attempt to bring in this new opinion, after the first trial, Dr. McBride issued a more formal recitation of his new opinion. Everyone was aware at least 27 days before the second trial that we were looking to present Dr. McBride's
As Judge Jacobus said, these aren't guidelines and suggestions, these are court orders. If you want to get around a court order, you file something called a motion and say, hey, we need relief from this part of the order because.
Yes, that would have been, in retrospect, certainly the better way to have done it. But in terms of what analysis guides the court's discretion in excluding that opinion, we need to apply a Binger analysis. And
Did you object? And when I say you, did trial counsel object at trial that said, Judge, you haven't applied Binger to this case?
I don't know if he said you didn't apply Binger, but he certainly argued for a Binger analysis, saying that, Judge, you need to consider surprise and prejudice. They knew about this weeks ago. And so the argument was made with citation to Binger, and the judge's analysis began and ended with the idea that my order is not a suggestion. And certainly that's true. But Binger presupposes that there's going to be a violation of a court order. That's always the case with Binger, because if it was a timely disclosed opinion, there would be no problem at all putting it in. So you're always going to have some type of issue with the timeliness of the order when you do a Binger analysis. And we've cited cases in our brief, Lugo, for example, where the court excluded an opinion on the basis that the judge said, quote, the order must be strictly complied with. And the appellate court said that's an indefensible ruling where the opponent was aware of the substance of the opinion.
But didn't the judge here find there would be prejudice to plaintiff to allow the testimony?
I don't believe he made any finding of prejudice. I think his analysis...
It was certainly discussed with the judge, wasn't it, or no? Are you saying it wasn't discussed at all?
I don't know that it may have been discussed at all, but he certainly made no finding of prejudice, and I don't think the record would support that. With the plaintiff aware of these opinions long before, certainly there was an opportunity to cure it. And the other thing, too, in terms of the ability of the plaintiff to meet Dr. McBride's opinions, although Dr. McBride was not able to talk about the 2013 scan that showed the herniation, Dr. McCollum, the plaintiff's expert, was able to testify that, yes, I'm aware of the 2013 scan. It may show a herniation, but that's really not what that film was for, so I discount it completely. So they were able...
Do you argue that that opened the door for McBride's opinion?
It was addressed on the front end, where the...
No, that's not my question.
No, no.
Once that was brought up, I mean, I could see an argument being made. I'm not saying it would be successful or not, but hey, if they're going to talk about it, our guy gets to talk about it. I believe that was addressed when the issue came up at the beginning of the trial, because if I recall, my trial counsel said, well, Dr. McCollum is going to testify about his review of the same records, and the response was, well, he's not an expert, he's not bound by disclosure things, he's allowed to testify about those things. So that type of issue, I believe, was brought up on the front end of the issue. It was not, to my recollection, raised again as now the door's been opened, because we'd already discussed it in the judgment. I want to keep talking about that. It's fine. If you'd like to address the permanency directed verdict, that'd be more to my liking, but it's your time. So.
Oh, well, thank you, Judge. Yes, and our next point is we believe the court erred in granting a directed verdict on the issue of permanency. Again, the plaintiff had 3 body parts involved here, the neck, back, and the shoulder. Everyone agrees that the directed verdict on permanency pertained to the shoulder injury. The defense expert in this regard, Dr. Halperin, testified unequivocally that he does not assign a permanent impairment to this, and he does not consider this to be a permanent injury. He said, yes, she had an orthoscopic procedure. It involved a little bit of bone being shaved down. And what he said was, if you want to define permanent injury as something's different in the body, then I guess you could say that. But that's not how I define it. He found that she does not have a permanent injury because her shoulder is fine. In addition, on top of that, we know that for, I believe, 2 years prior to trial, the plaintiff underwent no care for her shoulder, and there was no evidence she would ever need anything further for her shoulder.
Did Dr. Kugler, I think his name is, he was the shoulder surgeon?
Yeah.
Did he testify at trial?
He didn't testify. The only evidence of permanency with regard to the shoulder was in Dr. Kugler's record, where he assigns a 6% permanent impairment. And I don't even know if that evidence is what the judge relied upon to find that there was permanency. I think the judge was under the impression that anything changed in the body is a permanent injury as a matter of law. It doesn't matter what anybody says, and that's wrong procedurally and substantively. What we have in this case is unobjected to expert testimony that this plaintiff does not have a permanent injury to her shoulder. It's not for the court to say that unobjected to expert testimony is entitled to no weight and I'm going to grant a directed verdict. The other point is, as a matter of substance, I think the judge was under the impression that there's some kind of legislative definition of permanency, and there's not. We know from the case law and the instructions that there's been a deliberate attempt to not define permanency. We leave it to the experts to tell juries what permanency is. This expert says there was no permanent injury. There's one case I cited to the court in my reply brief. It's Emanuel versus Purdue, 693 Southern 2nd, 1071. It's a 4th District case. In that case, the plaintiff underwent a TMJ surgery, and the jury awarded medical expenses associated with the TMJ surgery, but found no permanent injury. The defense expert in that case said, notwithstanding the surgery, it wasn't a permanent injury. The trial court granted a new trial, and the appellate court reversed. Essentially, the result being the fact of a surgery doesn't necessarily mean permanency. Yes, there is something somewhat different in the body, but any surgery, no matter how minimal and no matter how small the change, isn't, as a matter of law, a permanent injury under Florida law. We had an expert saying there was no permanent injury, and for those reasons, it was wrong to grant a directed verdict.
You cited as well to Little versus Davis, correct?
Correct?
Surgery there, and the jury was free to find no permanency?
Correct. And yes, we did
Well, let
cite
me
that
ask you
case.
about the Wald versus Granger case,
Okay.
the Supreme Court version. In that particular case, it said that it agreed that typically, permanency is an issue for the jury. But if you have a situation where there is no evidence, no conflict in the evidence, then permanency can be part of a directed verdict, correct?
Right.
And in Wald, the plaintiff's experts said the plaintiff had a variety of permanent injuries, and one defense expert, a fellow named Dr. Howard Hogshead, agreed with the plaintiff that the thigh injury was permanent, correct?
That's my recollection.
And so the court upheld that permanent injury DV, right?
I honestly don't remember that. But my
But it
take.
placed the Wald case, even though it upheld that DV, placed certain limits and parameters on when a DV was proper, right?
My understanding, broad view of the Wald case is that even where the experts agree that the plaintiff sustained a permanent injury, there are circumstances where a jury can reject that and find that there was no permanent injury. For example, if the experts had incorrect medical histories, we don't even need to reach that. That's a case that tells us even where all the experts agree it was permanent, a jury could still find no. We don't have uncontradicted evidence of permanency here.
Not exactly what the case says, but
Oh, I'm sorry.
it says you can, but you can't just up and disregard all the experts. There have to be reasons to
Correct.
disregard the
Oh, yes,
experts.
the jury can do it with reasons, and such as an incorrect medical history that was given to the doctors.
Did plaintiff in this case argue, as far as the permanency, anything other than permanent alteration of the body?
He initially argued significant scarring, but then ultimately agreed the
He
significance.
agreed
I
that
think.
was a jury issue,
Right,
right?
and everyone agreed that the other ones, like loss of an important bodily function, was not at issue. The only one at issue was permanent injury within a reasonable degree of medical probability.
Right. And was there any testimony from any plaintiff's expert, testimony at trial that there was a permanent injury?
No, I don't believe there was. I
And
think
as far as, let me just ask you this, and so I can put plaintiff's counsel on notice to look there on his computer. I'm looking at Dr. Kugler's report at 2055 in the record. And it says, I think this must be the report that everybody referred to. Under the treatment section at page 2056, he says, others, clinical note, the patient at this point is doing very well concerning her right shoulder. She will be finalized. She is given a 6% impairment rating. Is there anything else about her having an impairment rating that you know of from the plaintiff's side?
no. I'm not sure that's the same medical record of Dr. Kugler that I've been citing to, but it's substantively the same. I was looking at a medical record from Dr. Kugler that assigns a 6% permanent impairment rating. That's
Look,
substantively.
while you're waiting on rebuttal.
I will do that,
Listening carefully to what he says, you can see if that's the right one or
Very
not.
good.
He can let me know if it's the wrong one, that's fine, but.
Okay.
Now, your expert was asked about Kugler's impairment rating, and he said basically that impairment rating is based on loss of motion, and I find no loss of motion, correct?
Yeah, he said a permanent impairment rating for this kind of injury is based upon range of motion, and whatever Dr. Kugler found at the time, I don't find a range of motion problem now. So he disagreed that there was a permanent impairment, and he also specifically said that there was no permanent injury because he doesn't consider this to be a permanent injury. But other than Dr. Kugler's medical record or report assigning a 6%, no, nobody testified at trial that there was a permanent impairment as a result of the shoulder. So I'll reserve the rest of my time.
All righty.
Okay, thank you.
May it please the court.
Morning.
Brian Lee, representing the appellee in this case, Ms. Gonzalez. I'm just going to go right to what we're talking about here, and the permanent injury. Obviously, we have arguments on the other 2 points, and I'm happy to go through any questions you have, but we are focusing on permanency. The evidence that the plaintiff had put forth through the medical record, and you are correct, we're looking at 2056.
That's the right record?
That's the right record, Your Honor, because it's talking specifically about the right shoulder. It's talking about basically the surgery that had taken place, as well, because it was 3 months, so this was a follow-up visit. And Dr. Kluger in that record says, as I think the court read, it says she will be finalized. She is given a 6% impairment rating. Okay, so there's and then later on in that same medical record, Dr. Kluger does talk actually about future surgery, future medical care that he believes that Ms. Gonzalez was going to need. He also said that she was at maximum medical improvement, and that she can come back. And so that was the evidence that was from the plaintiff's side. Under Wald and the portion of Wald that I cited to, what Wald says, or what the Florida Supreme Court says, is that the plaintiff has the burden, the initial burden, to put forth a permanency evidence. By this record, that did that. Once that's done, then the burden shifts to the defense. And what Wald says is that the defense has to put forth countervailing evidence that countervails it directly, meaning that, and they actually say direct evidence of permanency. So it's not a situation where a defendant can come in and say, well, I don't think that there is one, but I can't say that within a reasonable degree of medical probability, or something along those lines. I kind of call it the wishy-washy defense, right? You have
That
to,
was McBride's first opinions.
right? You have to come in and you have to say that I'm directly saying, as an expert, the defense expert, that there was no permanent injury. Now, this is a unique situation because normally when we're dealing with permanent injury, we're talking about separate injuries, right? So like this one, we had a shoulder injury, we had a back injury, neck injury. So we have separate injuries, and then we have a fight from physicians that one says shoulder, one says not. One may agree that there's a neck injury and there may not be any disagreement, but there's disagreement on the other. In this case, the defense expert himself disagreed with himself. And he said, and I've cited to this in my brief, when he was asked a direct question whether there was a permanent anatomical change in the body, he unequivocally said yes. He then says, well, I think of a permanent injury as a loss of bodily function. And she didn't have that. So I don't think she had that.
Where is permanent anatomical change a permanent injury? I looked at 627, 737, and it's 2 A, B, C, D.
It's not in there.
It's not in there, is it?
Doesn't say anatomical
It's not
change at
there.
all.
And that was your argument, that there was a permanent anatomical change, and Judge Jacobus said, yep, that's permanent injury.
The trial court, yes, the argument was that the specific argument was that that testimony satisfied a permanent injury under the statute.
Right, but permanent anatomical change
Correct.
is not listed under the statute.
It's not. And
There was testimony from defense expert that there was not a permanent injury, right?
I would disagree with that to the extent that he said that this part of my analysis, I don't think there was a permanent injury. The other part of the analysis that I make, yes, there is. So he said two different
he didn't
things.
say permanent. He said if you asked
Permanent
if something
anatomical
was
change.
changed,
Absolutely. But he said it was permanent.
words matter, right? Permanent change, he said, yes, there was a permanent change. I mean, if you had an appendectomy, that's a permanent change to your body, your appendix is gone. I don't know, I've never had it come up because nobody knows what the stinking appendix does, but, so you've had a permanent change of your anatomy, just like, you know, this person had a permanent change through shaving of the shoulder bone, but the doctor said, that's not a permanent injury to me.
But he didn't say that. My argument is that Wald says that there has to be a direct contravention, meaning that
Wald
there is
says
no
where-
permanent injury, period.
Wald says, and I'm looking at page 1204,
Yes.
nonetheless, where the evidence of injury and causation is such that no reasonable inference could support a jury verdict for the defendant, it's not improper to direct a verdict on that. And a directed verdict, again down at 1205, a directed verdict is proper when the evidence and all inferences from the evidence considered in the light most favorable to the non-moving party, the defendant obviously. As a matter of law, there's no evidence to rebut it, and it goes on to say, so when you examine the record, you need to determine if there's any conflicting evidence or inferences on the issue of permanent injury from which the jury could draw a conclusion favorable to the party against whom the DBs. And, well, there was testimony from defense Dr. Halperin that it was not a permanent injury. From that, the jury could draw the inference and reach the conclusion that there was no permanent injury.
But there was also testimony from him that and again, I understand when we look at the statute, we're talking about injury, right? There's a term in there. It's not defined.
Right. It's not defined at all, and
it's
they
not
pointed
defined,
out,
so-
they pointed out in the standard jury instructions, it's not defined, so don't try to define it. Leave it up to the experts in argument.
Sure, but when we have an expert, which we do in this case, that says in one instance there is a permanent change, and then one instance says, but in this other part of her function, I don't think that's permanent. That is not a direct, what Wald says, a direct conflict with the plaintiff's evidence.
There has to be a direct conflict within 2A or within 2B, but you can't say there's conflict between 2A and 2B under the statute. Does that make sense or not? In other words, 2B deals with permanent injury. So your argument would be that once you put on evidence there's
Right.
permanent injury, they've got to come back with direct 2B, meaning permanent injury evidence to counter that.
Yeah, I think I know where you're going, Judge. The way I would say it is that the statute is set up as an or. You either have to prove there was a permanent loss of function, or a permanent injury, or I think it's permanent scarring, if I'm not mistaken.
If you put braces on somebody's teeth, that results in a permanent anatomical change. When you take the braces off, you'd say that's a permanent injury?
I don't say it. I think that I think if a doctor came in and said that there was a permanent anatomical, now again, we're talking about a negligence case, but if a doctor came in and said there was a permanent change that those braces made to her body, and there's evidence that she's going to continue to have future treatment for that injury, that's permanency.
But you keep throwing injury in there.
Or change. I don't think the injury word has some kind of magical word phrase meaning that an expert has to say that it's an
Change and
injury.
is certainly not synonymous.
I'm sorry, what?
Change and injury are not synonymous. You're using them the same way. A permanent change is not necessarily a permanent injury.
I think the words change and injury are not synonymous, but permanent is.
Right, but permanent,
When you say permanent change, that by definition is permanent. When you say permanent injury, It's by definition permanent. We're
Permanent
talking
means
about
permanent.
permanency.
Yeah, and we're not trying to mince words over permanent versus temporary. I mean, whatever the change was to her shoulder as a result of the shaving was permanent.
Right.
Nobody's disputing that. The question is whether it's a permanent injury. Unless it's a permanent injury, you can't get these other damages, right?
That's what the statute says, permanent injury.
Right. The statute
But
says
we don't
permanent
know what the injury is defined as.
Your fella Kugler, and since defense didn't make a big deal out of it, I won't, but he says she's given a 6% impairment rating. It doesn't even say permanent, but they accept it as that. Everybody who's in the business knows that's a permanent rating. It doesn't get better, doesn't go down. It's going to be 6% when he says finalized. So he gives her the permanency rating, and Halperin says she doesn't have a permanent injury. And if Wald says you leave it for, and the jury instruction committee says you leave it for arguments and you leave it for experts, that didn't happen here. It was taken away. It was taken away. They weren't allowed to argue whether she had a permanent injury or not.
There is obviously a disagreement we have as
Tell
to
me the
what
case
that
that
is.
says a permanent alteration of the body equals permanent injury.
There is none. I can't
And
find
there
a
are
particular
cases that he
case.
cited to us, and we discussed, and I don't mean to be interrupted, you know,
No,
calm down a
absolutely.
little bit, but
Your time.
there are cases that say somebody can have surgery, the TMJ surgery, some neurological surgery, and the jury's free to find, despite surgery, that it's not a permanent injury. In fact, it was error, I think. I think in one case they reversed granting a new trial or a DV, whatever. But I mean, how can you have TMJ surgery and neurological surgery, and it's okay to say that's not a permanent injury, but you shave the bone when the doctor who testified says that's not a permanent injury. It's change, but it's not an injury.
Right. I mean, and the one thing I don't know, Judge, is in those cases, was there questioning about, the permanency of the surgery? Because there are situations where if you don't ask the question of the doctor that says, hey, did your surgery, just the surgery, cause a permanent injury to the body, then you can't bring that up. You have to then rely upon, oh, well, I think her pain's permanent, or I think the other things. So I don't know we can look at those cases
They're not as clear as you'd
and
like.
figure out.
Yeah, I mean, it says she had TMJ surgery, so that means they cut her open and did something with her jaws. We don't know what.
Right.
And the other one was neurological, and that was even more vague. She had neurological surgery, but the doctor said she would be doing better and continue to improve. And the Court of Appeal said, well, no DV on that, just because she had surgery, that's up for the jury. And that's really kind of where I see this.
Right.
And I understand what Kugler said, and they didn't fight that on any kind of basis. But when you've got Halperin saying there's no permanent injury, and you got Kugler saying there is, that's the classic question for the jury, isn't it?
I disagree, obviously.
Yeah.
But
I expect you to.
the way
Go ahead.
I look at it, and just to kind of end up, unless you have any questions, the way I look at it as this is no different than having a situation where there are two different parts of a shoulder that are injured, one of which heals fine, and one of which doesn't. You can have an expert, and this expert, we believe, said that as to this part of what happened in this surgery, that's permanent. He said change. He said anatomical change. I don't believe that automatically just takes it out of permanent injury, that it's not a permanent injury. He also said that as to the effects of this, I don't believe the effects of this are permanent. So he has two different opinions, we believe, one of which says there was a permanency, one of which says there's not.
But
And there's
he
a
didn't-
cause
he
and
didn't-
effect to that.
I'm sorry, go ahead.
No, all I was going to say is that Wald, in our view, says that you have to have a direct conflict with the evidence. If the plaintiff's evidence is that there is a permanent injury, and the defendant's evidence is that one part is a permanent injury and the second part isn't, that's not a conflict. Because the expert
If he
has
just
said that there
one-
is a
if he-
permanent
If he
injury.
just said the shaving the shoulder was a permanent injury, you're home free. He didn't. He said it was not. He said he doesn't think it, it's permanent anatomical change. And again, Walt says if there's any conflicting evidence or inference on the issue, there was conflicting evidence on the issue of permanency of the shoulder by the two doctors, one from the defense and one from the plaintiff. And, I guess we beat that horse as much as we need to. You're free to talk. You've got time left if you want to talk about anything else.
No, Judge, the only thing I was going to, the other two, obviously I've briefed, just to touch on the first issue about the disclosure and those types of things. The only thing I would say is that prior to the trial, there were the two reports done by the doctor, and neither of them said what the opinion said. When we got to the first trial, all of a sudden now there's the opinion. What I would also add to that is that as part of that trial, the defense counsel not only said, we're not going to have that opinion, we're just going to read his testimony. We're going to have him come in, and he's not going to testify about that. But now we go to the second trial. It was mistried for a reason that's not in the record. The only thing that I can gather is from a motion that said that the judge said it wasn't fair. It wasn't a fair trial. We don't know what that is, but
Nobody appealed it.
But nobody appealed it. And so what we do have is we have the trial judge days afterwards enter an order which specifically says discovery is frozen. Frozen's my word, but essentially there is going to be no discovery. And then after that, even with that, we have a new report. Binger specifically talks about the discretion a trial judge has, and specifically says that a trial judge has almost absolute discretion about how it's going to enforce its own orders.
And it let the testimony, McBride's testimony, come in as to the old things he had to say, right?
They did.
Not as to the new opinion.
Right. They read the transcript, from the first trial as his testimony.
It's not the plaintiff's job to make it easy for the defense expert to come in with a new opinion, right?
No. And the trial judge.
They did nothing that you would have expected. When you get the order saying it's frozen, we're done, let's go, this one's baked, let's just go try it again. They did nothing pre-trial to try to seek relief from that order, did they?
Not that I can see.
Oops. So, okay.
I'm sorry.
Go ahead.
On the third issue, I'm struggling a little bit to see why it was not an incomplete instruction by having the limitation for permanency as to just the right shoulder, because that's the only portion of the body that was at issue, correct?
Correct. So the reason that we believe that it was an appropriate instruction is that when you look at the standard instruction for permanency, it doesn't differentiate between different injuries.
Well, okay, the standard instructions only get us out to the starting gate.
Sure.
They don't, okay.
But I think the bigger part of this is to go to, I think it's Wald again, because Wald talks about that when there is evidence, when the jury finds, or it's directed verdict, of that there is a permanent injury, right, it's A, then you can get those damages for all injuries.
Whole or in part.
Whole or in part, right. And so that's what the trial court looked at, and why we think it's appropriate to have that jury instruction, because number one, they gave the instruction as the way it was supposed to give, and the way that the law says you're supposed to, because it's a permanent injury. But then number two, the trial judge did not stop the defense counsel from talking about, the shoulder surgery, the judge said, but basically explaining the instructions.
But couldn't the jury have felt, okay, well, they said there's a permanent injury here, and we find that it's to the neck and back, therefore we're going to award damages as to those.
They could have said that we believe that the neck and back are permanent. They could have also said, well, we believe with what the defense counsel just said, that it's really the shoulder, and that's it. So we don't know exactly. It's kind of it's speculation to figure out what the jury said, but the instruction itself, meaning there was a permanent injury that was found.
A permanent injury, right?
Right. And it doesn't say, the instruction doesn't really give, and frankly the law doesn't give the ability to parse out injuries in that sense for a jury instruction.
Didn't she have a lumbar fusion?
She did. She did. But there was evidence that that wasn't caused. right? So it was very direct. So yeah, and again, at the end of the day, the instructions given, counsel was able and extensively talked about what the jury should do about the injuries. And so I believe that the instruction that the judge gave was appropriate according to not just the standards,
If
but
the
the law.
judge
too.
had put in the limitation, though, would that have been a problem for you? Would you have appealed?
Frankly, I think it would have been a problem because part of and not for the permanency aspect of it, for the damages part of it. Because even if a court says or directs in this case a permanency, you can argue damages, and so you can argue in this case that the lower back shouldn't factor into that damages claim because it wasn't something, our doctor said it wasn't permanent. So you can make those arguments, I think, but it's more alongside the damages part of it rather than whether there was a permanent injury. The permanent injury instruction only allows you to get that question off the verdict form. The jury doesn't have to check yes to that question now. The damages questions are still there, and all the arguments are still available for those questions.
And that's your last argument. Thank you. You're out of time.
Thank you, Your Honors.
All right.
First, the citation to 2056 is what I had been referring to, so I think we're all talking about the same record from Dr. Kugler.
You agreed from reading that document that Kugler was of the opinion that it was a permanent impairment of 6%, right?
That's what it says, certainly.
Okay.
Whether an impairment equates to a permanent injury, I guess there's some debate about this.
But that's what you ask a doctor, it's a permanent injury, they go, well, that's a legal term, we say impairment, right?
Right, and this is a medical record, so it makes sense that it would be speaking in medicalese rather than legalese. A few points. On the directed verdict issue, I think I understood counsel to argue that there was something internally inconsistent with Dr. Halperin's testimony, but I don't think that's true. I think Dr. Halperin was specifically distinguishing a permanent change from a permanent injury. He wasn't inconsistent. He was saying that these are two different things. What he said is, the way I define permanent injury, she doesn't have a permanent injury. Okay, you can't be more definitive than that. He says, she's fully functional. If you want to define a permanent injury, something is different inside of her body than it was before, you could say she is. But the way I would define a permanent injury is has it limited her after she's done with everything she went through? Is there a problem? Is there a limited motion? If the answer is no to all of that, I don't consider it a permanent injury. It's a clear, definitive, unequivocal. It's not an initial McBride opinion. It's a specific Dr. Halperin opinion. He's not internally inconsistent. He's saying that it's not permanent. Wald didn't change the standard for a directed verdict. We know you take the evidence and all inferences in the light most favorable to the non-moving party. Wald gives us some scenarios when a jury can reject undisputed expert testimony and still come to the opposite conclusion. That's not us. We have conflicting expert testimony.
In the Wald case, the judge directed verdict on permanency only as to the thigh. I'm telling you that because I know that. I'm asking you the question that I don't know the answer to right off the top of my head. Did the judge, and that was a he or she, did the trial judge in that case give the standard jury instruction that there is a permanent injury? If you don't know, don't feel bad.
I don't, and I want to talk about the instruction. It was my hope to rely on the brief, but it did come up, so I do want to address it. Before I turn to that, though, with regard to the distinction between impairment and permanency, I think the Purdue case, the one that we talked about earlier, if I recall, the defense expert in that case said that TMJ surgery was rateable as a permanent impairment. I believe he said that. I was not able to pull it up when I went back to counsel table, but he still said, but I don't find it to be a permanent injury. So I think this demonstrates that among medical professionals, something could be rateable as an impairment, but still not a permanent injury. And of course, the court in that case said it was a jury question whether the TMJ surgery was permanent or not. So we think that was error. With regard to the instruction, I don't disagree that a permanent injury to any body part here would allow non-economic damages as to the entirety. But that's not the problem with the instruction that the judge gave. By telling the jury that it's been determined that this accident caused an injury and a permanent injury, without saying that this was limited to the shoulder, it wasn't purely about what could the jury award non-economic damages for. it's suggesting to the jury that more than just the more than just the shoulder injury has determined to be permanent. It's telling the jury that it's suggesting to the jury that these injuries that you could find are not even caused by this accident are caused by this accident and are more severe than the jury might actually find. It's not just about the
The
permanent
instruction said
injury.
there was a permanent injury, and whether or not
Yeah.
the directed verdict should have been given. Once the directed verdict has been given,
Yeah.
to say that the court instructs you that there was a permanent injury
Right.
left defense counsel total freedom to go, well, shoulder, everything else is not related, don't give any money for that.
Well, and that's their argument. They're saying we weren't constrained in our closing argument, and that's true. But we know that the jury instructions are instructions from the court. The lawyer argument is lawyer argument, and if it's going to be perceived as conflicting with the instruction or being in tension at least with the instruction, that doesn't solve the problem. That makes the problem worse. Now you have a lawyer who's saying something that could be viewed to be not consistent with what the instruction is. There was no reason why, and I understand, the argument is we need to stick absolutely and strictly to the standard instruction. Not every scenario is covered by the standard instructions. We have 3 discrete body parts at issue here. The directed verdict was only as to the shoulder. There was no reason to tell the jury that she suffered a permanent injury, but the defense is going to dispute the spinal injuries. I think there was, and as far as speculating what effect it had on the jury, we know that we can't get inside the jury's heads, and that's why the standard on appeal is there a reasonable likelihood or a reasonable possibility that the jury was misled? You don't have to show a certainty of them being misled. I think this instruction certainly did create a reasonable likelihood that this jury was led to believe that the ruling was not limited to the shoulder. If we look at what the verdict was, every dollar requested was awarded plus substantial non-economics. There's no question the jury awarded for all the body parts. And as far as the low back surgery, of course, yes, she had a low back surgery, but causation was the issue there, and that was part of the instruction that the judge gave. So unless there's any other questions, we would ask the court reverse for a new trial.
No, it doesn't look like it. Thank you very much, and thank you both. Very well briefed, well argued.